Okay, welcome to the third installment of the sentencing intro lecture. So this one is all about the evidence-based sentencing app that uses the courts to make an equal protection ruling. There are several things that are important to know about this. So in contrast to that first version of the app that is like evidence-based sentencing is bad and we should not do it, this version of the app says that currently it's bad and ineffective, but that the algorithm needs to be changed in a pretty fundamental way in order to fix that. Specifically, this app says that right now, a huge part of the problem, and the reason there's all this racial bias in the outputs, is that these risk assessments take as given and value neutral all of these inputs. Things like, again, criminal history, which is very much, heavily correlated with race, and is not a thing that exists in a vacuum, but instead is something that's very heavily influenced by, decades, centuries of racial and socioeconomic discrimination and, very deeply rooted disparities that mean that you are overwhelmingly more likely, for example, to be arrested for a given crime if you're Black. You are also overwhelmingly more likely to commit some set of crimes if you're Black for a set of kind of like deeply rooted, again, socioeconomic reasons, and so on, right? And so in taking all of those things as given inputs and deciding based on that to kind of like sentence people based on their future recidivism risk necessarily guarantees that you will be sentencing far more Black people far more harshly than whites. The way that these authors propose to fix that is by not blinding the algorithm to race and trying to pursue kind of a formalistic colorblind equality of the same sort that like mandatory minimums did, right? Just looking at it and being like, the thing that we need to do is just like treat everyone equally. We need to like stop paying attention to race and it'll all be fine. Instead, what we need to do is proactively consider race and the effects of race and actively counteract them in the outputs of this algorithm. So quick TLDR, this is a little bit imprecise, but it's close enough for kind of the way you're thinking about it right now. A way to think about this is you exclude, as many people currently do, again, because of fears that it would be unconstitutional to directly consider race and gender. They'll like exclude those. So like they won't consider those directly in the algorithm, but they will, like I've said, consider zip code, educational attainment, blah, blah, blah. This algorithm would be like, okay, it would run that algorithm, figure out what the kind of output is in terms of the degree of recidivism risk that it thinks a given person presents. Then it would be like, okay, now I'm going to explicitly consider this person's race and see what does that person's race predict, at least, if you feed that into the algorithm as a very heavily weighted factor, what would that predict that the recidivism risk will be? And then once you have those kind of values and the way that the algorithm arrived at those values, you can figure out how much of the expected recidivism risk is actually a heavy correlation with race, how much of it is attributable to, at least at kind of a deeper structural level to an individual's race, and proactively try to subtract that from the decision, from the kind of initial algorithm's prediction, right? So the goal here is to isolate just the predictive power of these other variables alone in a vacuum. Things like your actual education, educational level, et cetera, right? And actively subtract the effect of race. That currently would be unconstitutional to do. And the reason for that is because the Supreme Court, increasingly over time, and especially under Chief Justice Roberts, has coalesced around an interpretation of the Equal Protection Clause of the 14th Amendment that explicitly, that bars any kind of direct consideration of race, or rather, doesn't prohibit it, but subjects it to what's called strict scrutiny. So like a very high standard of review. I won't get into the details too much here, but happy to answer specific questions about that if you have them. As a result of which, so Roberts has this pretty famous quote from a few years ago in a court case in which he said, the way to stop discriminating based on race is to stop discriminating based on race. And what he meant by that was the way that you stop racial discrimination is stop talking about race. You stop, including race as an explicit consideration in laws and stuff. But that is not how that works at all, because of the degree to which, again, centuries of kind of accumulated structural and systemic inequalities are layered on top of each other in our system, such that we are all in a very different starting point, which is, again, why these uniform mandatory minimums produce racialized effects. It's why these actuarial risk assessments produce racialized effects. And so in a way that very directly parallels the affirmative action context, which is actually what Roberts was speaking to when he said that. He was like, affirmative action that directly considers race is bad, unconstitutional, and racially discriminatory against white people, against Asians, et cetera, because of the fact that it actually takes into consideration someone's race. And even took that a step further and was like, considering whether someone is Black and kind of helping balance the scales in their favor if they are, does that person a disservice and is discriminatory against them as well. Like that's, a thing that a bunch of conservatives claim. And so in contrast to that, this affirmative argues that the Equal Protection Clause, and so that way of understanding the Equal Protection Clause is often termed an anti-classification approach, by which what we mean is under the Equal Protection Clause, there are various different classifications that the Supreme Court has established over time of a kind of protected group against whom this sort of discrimination is constitutionally barred with kind of varying different standards of review. And one of those is race. So can't discriminate against somebody based on race is the rationale, at least the idea. So the anti-classification approach is like, you as an individual are a member of that, or sorry, of a law that is passed that explicitly on its face discriminates between two races, has violated that anti-classification understanding of the Equal Protection Clause because it has made use of that classification. But if it's facially neutral, then for the most part, it is largely fine. The one exception is if you can prove a very clear intent to discriminate, then it's possible that it still will kind of fail a challenge, especially if it's brought under, one of several civil rights statutes. Don't want to get too deep into the weeds on that right now, but so the result is essentially either it has to explicitly be like, we're going to treat Black and white people differently, or there has to be a bunch of like very clear conclusive evidence. In general, this is a little bit of an oversimplification, but very clear evidence that they passed it intending to discriminate in that way. And even then, sometimes the outcome can be kind of questionable. In contrast, this app says that we should adopt what's called an anti-subordination approach, which instead of being like, did you use that classification or not, focuses on the effects. So you'll often hear people use the phrase disparate impact. And so instead of disparate treatment, i.e., did you directly treat this person who's Black and this person who's white differently, disparate impact is focused on, does this law and policy have results that are disparate between, severely disproportionate between those different races, like much more negative for members of one race than members of another. So for example, housing policy often will have a disproportionate negative, a very disparate negative impact on Black people who are locked into certain situations, white people are not, because of the kind of very long history in the United States of housing discrimination that kind of serves, and white flight, et cetera, that have served to construct the situation in which even a facially neutral policy will affect people very differently. So this app says that the Supreme Court essentially should rule that the Equal Protection Clause is, takes into consideration disparate impact, which is the thing that the court right now has firmly said no, and that it is acceptable and arguably even necessary to kind of identify and counteract that sort of disparate impact by explicitly considering race, instead of adopting this kind of colorblind approach that the court has right now, where it's just like, shut your eyes and ears and try to ignore it and it'll go away. And then says, because of that new interpretation of the Equal Protection Clause, use of these algorithms at sentencing need to adopt the kind of algorithmic approach I talked about a little while ago that seeks to kind of proactively balance the scales, right? So the kind of buzz phrase for all of this is algorithmic equal protection, algorithmic affirmative action, because that is the idea. It's like, need to look at the effect and then kind of proactively counter it. Now, the reason that is so important in terms of the broader precedent it sets, the AF wants to say, is because we are, as people increasingly are using algorithms, and it's very difficult to tell kind of what the inputs were intended to mean, and what the kind of goal, like machines obviously don't have an intent. They cannot, by definition, have any intent to discriminate. And, like I said earlier, to avoid constitutional concerns, people super frequently are not including as explicit considerations things like race. But like I also talked about earlier, just about everything else in the United States is very heavily correlated with race, such that they are essentially a proxy for race. And so, if not extremely careful in the design of all of these algorithms to very proactively counter, as opposed to just try to ignore or whatever, that racial bias in outputs, it is essentially inevitable and guaranteed that the outputs will be very racially disparate in a way that has very negative implications. So for example, when somebody's making a credit lending determination, algorithms are increasingly being turned to do that, because they can consider all kinds of different bits of information about you as a person and put all those together and figure out like where there are patterns and how likely it is as a result they'll be able to kind of repay a given loan. But absent proactive intervention to prevent this from happening, that machine is very likely to latch on to, this set of variables are very heavily correlated, and end up systematically denying access to credit to Black people who are in a very similar socioeconomic situation on paper to like a given white person. And that is the thing that, more than anything, this plan seeks to make it both possible and mandatory to rectify, right? So the result of all of this then is, right now, if you were to try to challenge one of those algorithms and be like, it's very clear that Black people are being systematically disadvantaged in this important area, that is inherently, that's unconstitutional according to the Equal Protection Clause, the court would be like, nope, they are not directly considering race, it's fine. After the plan, that would not be the case. That would be kind of constitutionally actionable. And the plan kind of paves the way directly toward being able to kind of hold those people liable, so they therefore are incentivized to fix their algorithms early on in the process before that ever happens, which is necessary to prevent all of this from becoming baked in. But it also, even if it were to happen, provides a very clear precedent and method statistically for actively counteracting that to kind of undo some of that damage. So I hope that makes sense. You definitely should kind of read through the file. It is pretty complicated. I'm sure that there will be a bunch of questions. Please feel free to ask. Take care.